Good afternoon. Okay, so I'm just going to share a little bit of the recent studying up I've been doing, which is kind of part of the job in general to stay abreast of changes in the Social Security laws, not just in my own local area, but because I do national in all the different circuits. So in this case, we have another share by Adriana De La Torre, who's fabulous and generous with her shares. And this is a Seventh Circuit case that was done a couple of months ago. And this one is kind of something that can help claimants, I think, because it addresses things that would be kind of broad in their cases. So let's take a look, see. In this case, it addresses how the ALJs are supposed to handle RFC, residual functional capacity assessments for claimants with psychological impairments. In this case, and this is a case of Keck versus Commissioner of Social Security, she was in her early 40s, so she was a younger individual, right? Anyone under 50 is younger. When she applied for SSD, she'd had a breast cancer diagnosis with a lumpectomy, had chemotherapy, but apparently had to discontinue treatment due to severe side effects, which included apparently extreme fatigue, shortness of breath, and difficulty balancing. These are particularly the first two. I see these a lot in chemotherapy-related treatments, particularly of cancer. As we know, chemotherapy is apparently a poison. So it's not unexpected that it's going to do some damage while trying to obviously kill off the cancer. Apparently, her medical records do document symptoms like chronic pain, depression, anxiety, nausea, and dizziness. Okay, and by the way, this is going on back in like 15 and 16. That's how long it takes for some of these cases to make it up the pike. That's a pretty long time. Now, granted, we had COVID in between. I don't know if that had anything to do with it, but the fact that this just comes out in the end of 2024 or second half of 2024 kind of goes to show, because it doesn't always happen that way. The state agency psychologist, so that would likely be the consultative examiners, put her, I take that back. Well, yeah, perhaps it was a consultative examiner. I was thinking maybe it was the medical expert that doesn't examine the person, but then just sums up the records and determines an RFC. But whoever it was, it could have been the guy that actually examined her mentally. He or she assessed her mental capacity and determined that Ms. Keck would be off task for up to 10% of the workday and had moderate limitations in other areas. So off task, by the way, guys, is not something that's defined in the DOT, Dictionary of Occupational Titles. So ultimately, it's usually a vocational expert who will give an opinion, like at a hearing, due to their experience of being a vocational expert and placing people and et cetera, as to what off task would be tolerable to up to what extent by an employer. Some say 10% and no more. Some say 15. I've seen some say 20. I think the one I see the most is 15 would either be the max or at that point it's intolerable to an employer. Okay. So in this case, some of the evidence therefore said that she would be off task for up to 10%. And that evidence came from the state's own, the SSA medical person, psychologist, whatever. Now, the ALJ's RFC, despite that fact, the ALJ who, has to determine an RFC, given the evidence he sees, he or she's, to conclude that the claimant, Ms. Keck, could perform simple routine work with simple decision-making and no multitasking. He also ruled that she could maintain a regular, non-variable pace within a job. But what the circuit court, I guess, held was that the ALJ failed to account for the off-task limitation, that 10% that was expressly noted by, a medical evidence provider. Nor did it address the effects of her fatigue and mental health challenges on her ability to sustain those simple tasks that she could otherwise do, sustain them over an entire workday. So I am really digging this, guys, because we see this a lot. There is not an unmentionable amount of people with chronic fatigue, which is a really difficult, not impossible, difficult impairment condition to prevail on, because oftentimes there's not markers and they find it to be subjective. How fatiguing is it? Like, everybody who goes to work gets fatigued, true, to the best of us, but not addressing it when those are symptoms would be, in my opinion, and apparently this court's too, failing to address a reality, or at least say that you don't believe she's fatigued and explain why, right? But if you're going to find that she has fatigue, as one of her symptoms, then the ALJ apparently has to account for how that would affect her ability. It wasn't necessarily to not show up for work. I don't think it was saying that she wouldn't show up. So it wasn't necessarily an absenteeism, but would it interfere with that, sustaining that kind of job that he's found she could do, that simple little job, with a non-variable pace? And what else did he say about that job? No multitasking, routine work, simple, unskilled work. And I think that the end point is, if you're going to find they can do that, you then have to address if they can do it for the full 8-hour day, 5 days a week. I think that's where we're going to here, going with this. On appeal, Adriana shares with us that Keck's primary argument was that the ALJ overlooked her moderate limitations. So she doesn't say that they are extreme, but moderate limitations in concentration, persistence, and pace. If you listen to a recent video, we talked about moderate limitations when it comes to mental tasks like concentration, persistence, and pace. And moderate limitations generally won't get you mentally disabled due to mental. In other words, that's not going to knock out all 12,000 jobs. You have to have physical, which obviously this lady does. But I just want to drive home that point, that the word moderate in those kind of cases is a loser word if you're going to be found to be able to do moderate, or only be moderately limited, as opposed to markedly or extreme. But when that's not the reason, not the full reason why you can't work, because you got these other things, then it's a whole different story. Because again, it depends on your vocational profile and the rest of your impairments, and how we're going to thread that needle and make that path from an able person to a disabled person of the law. So the Seventh Circuit, again, this is the Seventh Circuit. As you know, we talk about all different kinds of circuits around here, and all have something to share that can be good in any other circuit. It won't necessarily be binding on that circuit, but it can be very persuasive, in my opinion. I think ALJs are going to listen. So unless their circuit holds something entirely contrary, if their circuit hasn't discussed it at all, they might listen to that other circuit and be like, that does sound right. Anyway, okay, so the Seventh Circuit agreed, ruling that the ALJ did not properly or adequately consider whether Ms. Keck could sustain even simple routine tasks over time. So this is a whole sustainability evaluation, really, and how finding that she could generally do simple work doesn't mean she could do it for 8 hours, or maybe 8 hours, 5 days a week. And that is what they ended up remanding on, and sending it back, because the ALJ didn't address whether she could do it all day long, just that she was generally capable of doing simple work. So you might be able to do simple work for 2 hours, and then you might fuzz out, whether it's the brain fog or the fatigue, the body fatigue, depending on what your impairments are. So I think this is a really good one, and I think I want to take a few notes on it myself, because I do see a lot of time. My argument is often that she can't sustain this. Like, yes, she could do light work and be on her feet for, 2-3 hours a day, Judge, but between the need for the nap, the chronic fatigue, or the sustainability is not there. And they often won't address that. So now we have a case, granted it's Seventh Circuit, but I would probably mention it, anecdotally, of course, in a non-Seventh Circuit case, just because I like to do that if that's the only one I find that says that. Obviously, if I can find one in my own circuit, that would be even better. But that would be useful to, now, strategy-wise, do I do that before the hearing, or I do that probably, I don't know. That's a whole other thing I don't even want to talk to you guys about. Do I do it on appeal and get the different bang for the buck? I don't know. The court cited a different case called Crump versus Saul. Now, Saul was a prior commissioner, and this was a 2019 case where the SSA, the courts noted that in that Crump case, a claimant's ability to perform basic tasks doesn't address whether they can maintain those tasks consistently throughout the day. So they're pointing out exactly what we're just talking about. Just because you can do them generally does not necessarily mean anyone's saying you could do that for an 8-hour day. So that's a good point out. So if a judge doesn't say, oh, I find she could do that for an 8-hour day expressly, or there's there's reason to think she can't, it might be a helpful point on appeal. And that whole point was particularly relevant in Ms. Keck's case, where multiple psychologists apparently had noted her limitations in concentration and her need for frequent breaks. So this take home for me is kind of that if a person has limitations in concentration, that it's possible that those do affect her ability to do even a simple job that doesn't take a lot of brain thinking. And they also point out the need for frequent breaks could also then therefore affect the sustainability of the work effort. They didn't really tie in, at least not from this summary, about the 10% business, except that the judge never addressed the 10% business. We'd have to look at the case to see, did the judge ask the VE about the 10%? Did it even come up? Or was that completely ignored? I have a feeling he or she did not ask the vocational expert that. And because that was a piece of evidence, he could disregard the 10% and say he didn't find it, but he'd have to address it, I believe. It might be that important of a piece of evidence that the judge has to address it and why he doesn't find that the 10% would apply or what have you, whatever the case may be. But can't just ignore it. It goes on to say that the court also rejected the SSA's argument that Ms. Keck could still perform jobs in the national economy, noting that the ALJ hadn't properly incorporated Ms. Keck's off-task limitations in the hypothetical posed to the vocational expert. All right, so that's it. The judge never asked the vocational expert, well, what if the person is going to be off task for 10 minutes? Would this job be available? Would she be able to perform it satisfactorily? So, those are the things when you go, this is a reason why I would say if someone is doing an AC brief, let's say you've gotten out of an ALJ, you got an ALJ denial, and you're going to do an AC brief. If you weren't on the case yourself, like as a representative, say you're a representative, or if you're a claimant, you obviously are, but if you didn't study your own evidence very well, this is going to be a dilemma, because I think it's really important to know the evidence so that you can, as soon as that hearing's over and you're like, the judge didn't even do this, or when you get the denial really more accurately, because you know what's in the evidence. Now, if someone's coming on board to do an AC appeal, which is probably, or to do a brief for you for the AC appeal, which is probably something you'd pay a consulting fee for, they're going to have to go through and try to find they have to read the evidence. We get cases with like thousands of pages of evidence. I know some people think if they got 500, it's a lot. That's not really a lot. I see most cases have far more than that. But I will say also that sometimes those cases with very few, quote unquote, 500 or less pages, sometimes they are the strongest cases. So it really depends. Every cases are different. Some people have a plethora of severe but not major impairments that they treat for, all of which nick away the functionality that they have. And some people have one big bad one. And that's, less records because there's not 20 specialists, there's 1 or 2. So, okay. She sums up by saying, Adriana sums up by saying that the court's decision is a reminder that the RFC, residual functional capacity, must reflect all of the claimant's limitations. In particular, here we're talking about the off task of 10% that was noted, perhaps. So it would be the mental, it would be the physical, and the cognitive. Now, I kind of consider cognitive under the mental, but in a sense, it's not. You can have a cognitive loss and have no mental health issues, but you have a cognitive loss for different reasons. So, and in this case, the reason was probably the chemotherapy side effects and damage done by the chemotherapy. Just guessing, given the nature of the case. Anyway, in the end, the Seventh Circuit did vacate the judgment and remanded the case for further proceedings, which means it goes back to the SSA to, I think usually the AC might take a little look at it sometimes. And if they can't give a flat out approval, which they usually can't, it goes back to the judge that had the original hearing, and you get another hearing with the same judge. I know that bothers some people, but anywho, that is really good to know, guys. The things that the judge doesn't mention, even to refute them and think that they're not credible, are the things that you can point out and appeal when they affect functionality. So good to know. Off task, concentration, reduced, blah, blah, blah. Sustainability of even minimal, easy job. They can do it, but can they do it for 8 hours a day, 5 days a week? All right. Bye, guys. Take care.